Hello, and welcome to the eviction section of the U of E Justice Center website. My name is Diana, and in this video, I'll be going over what an eviction is, the eviction process, and how to file an answer form with the court. An eviction, also called an unlawful detainer, is the process by which a landlord removes a tenant from their rental unit. There are many reasons why a landlord may evict a tenant, like continuously failing to pay rent on time, breaking certain conditions stated in the lease, or causing damage to the property. A landlord cannot, however, evict a tenant based on their race, gender, religion, or any other categories protected from discrimination. He also cannot evict a tenant to get back at them for some legal action they may have taken against him. The following 7 steps show a basic timeline of the eviction process that applies to most tenants. If at any point during the eviction process you and the landlord come to an agreement, this agreement can be written up and the case dismissed. Step 1. The landlord gives the tenant written notice. In order for a landlord to evict a tenant legally, they must first give them written notice to move out or give them a chance to fix the problem. After the time on the notice runs out, usually 30 days, the landlord can then begin the process for filing an eviction case. Step 2. The landlord files the complaint with the court. The landlord will file a summons and complaint for an eviction with the court to get the case started. After filing, the landlord must then serve the tenant a copy of the summons and complaint. Next, the landlord serves the tenant in one of 3 ways. Personal service is when the landlord or someone else gives the tenant the papers directly in person. Substituted service is when the landlord leaves the papers with another adult member of the tenant's household or someone in charge of their place of work. The landlord cannot use this type of service until they have tried serving the tenant at least 2 or 3 times on different days and times. With posting and mailing, the landlord can only use this type of service if the court gives permission. If there is no one home to leave the papers with, the landlord can tape the papers to the front door and send a copy to the tenant by mail. Next, the tenant decides whether to file a response with the court. Once the tenant has been served the summons and complaint, they have the option of filing a response with the court. If they wish to defend themselves in the case, they must file a response with the proper legal form and within the deadline. The deadlines for responding are: if they were served in person, they have 5 days to respond. This does not include weekends or court holidays. If they were served by substituted service or posting and mailing, they have 15 days after the date the server mailed the court papers to them. If the tenant decides not to file a response with the court, the landlord can then evict them without them having a say in the case. An eviction on record can damage their ability to rent in the future and can significantly lower their credit score. Step 5. The tenant files the answer form with the court and serves the landlord a copy. This form is called UD 105, and it must be served to the landlord within 5 days of filing with the court. Here is what the form UD 105 looks like. This must be filed with the court and a copy served to the landlord before the 5 days are up. The landlord would be considered the plaintiff and the tenant would be considered the defendant. Next, the eviction will go to trial. Once the tenant has filed and served the answer on the landlord will request a trial date. The tenant will receive a letter from the court clerk stating the exact date, time, and location of the trial. This will usually take place within 20 days. Here are a few helpful tips on how best to prepare for your unlawful detainer case. Get as much information related to your case as possible and take the original documents plus 3 copies of everything you take to court. These can be papers, photos, video, any evidence that can help show the court why you have the right to continue living there. Some examples would be the lease or rental agreement, the notice you were served with, letters you wrote or received about the unit, photos or video showing damage to the unit, photos or video showing unsafe or unhealthy conditions, any reports to code enforcement, and building inspection reports. In order to prevent an eviction, the tenant must prove one or more of the following: that the landlord broke his promise to keep the rental unit safe and suitable for living in. More information on habitability can be found under the living conditions section of this site. Discrimination, meaning that the landlord is evicting the tenant based on one or more protected classes, such as gender, race, sexuality, religion, or citizenship. Or that the eviction is retaliatory. This means that the landlord is evicting the tenant as payback for some other legal action they may have taken against him. The final step is receiving judgment. If the tenant wins, the judge or jury may decide they have the legal right to stay in the unit. If so, the judge or jury may order the landlord to pay the costs, like filing fees and attorney fees and court fees. The judge may also decide how much rent the tenant will have to pay. If the landlord wins, the judge will give them a judgment of possession. This states they have the legal right and ownership of the rental property, and the tenant will be required to move out. The judge or jury may also order them to pay back rent, damages, and other costs. After the trial, either side can appeal if they are unhappy with the judge's order. They can file a motion to set aside or cancel the judge's order. There are strict deadlines to do this, and the side appealing needs a legally valid reason to do so. The only way to stop or delay an eviction is by asking for a stay of eviction. The tenant must file the stay as soon as they get the notice from the sheriff giving them 5 days to leave the unit. A stay will delay the eviction. If the judge does grant the stay, the tenant will still be required to pay rent for that period of time. The amount of time the tenant can stay in the unit will depend on the county and case, and there needs to be a good reason to ask for more time. There are no court forms to ask for a stay, so please speak to a lawyer for help. This concludes the ULV Justice Center video on evictions and the eviction trial process. I would like to thank you for visiting our website, and I hope this video has been informative and helpful in your legal matter.